Hey everyone, I'm here with Dave Kennedy. Hey Dave.
Hey, how are you?
I'm great. How are you?
I'm good. We're staying busy, so we're
That's
good.
good.
Yeah.
Dave is with Selby Land Title, and we've had a couple of conversations here recently about POA,
hmm
and some of them have been okay, and others haven't. Can you explain like exactly what is the power of attorney, how it works, why some of them didn't work? I mean, I have a lot of questions. As
Right.
yeah.
Yeah. Yeah. No, I think it's a great topic because it comes up a lot in our industry. You have different situations where sometimes somebody's not available to do a closing. So sometimes they'll ask, can I use a POA? So POA is a short form for power of attorney, and it essentially just grants somebody rights to sign on your behalf.
It
Um,
happens a
the,
lot with our clients if their kids are handling everything. Like if they're older,
right.
they're like, I just wanted to sell it. It's mostly sellers though. I haven't
Right.
really seen it on a lot of buyers.
Yeah, and that's why I was kind of hoping we could limit our conversation more towards the seller because a buyer, you're right, it kind of opens up a whole can of worms. A lot of times it's really up to the lender whether they're going to allow it, and there's all kinds of certain parameters that it has to go, and sometimes lenders won't even allow it. So for the most part, we see them again in a seller situation. Like you said, it's either an elderly person, maybe could possibly be in a nursing home, can't travel out to do a closing, or it could be just a situation where you have a spouse that is not there or deployed, or, there's all kinds of different situations that would maybe sit there and say that this seller is not able. But, I'm kind of wondering if the future, our past conversations might come up with the whole e-notarize thing. Power of attorneys might actually go away in these transactions because if we could close this virtually, the use, power of attorney might not even be relevant
It might
anymore.
not, but sometimes it might still. You know what I mean? Because like you
Right,
said, if there's like a
right.
spouse or like a, yeah, like an aging parent or something like that. So I know that when we looked at, there was a power of attorney that one of our clients had, like their attorney had prepared it, but it wasn't right and it wasn't acceptable. Can you, like, what exactly happened? Why was
Yeah,
it not
yeah.
right?
Right. Yeah. So that's the main thing that I want to hit on is if you're an agent or if you're going to be buying or selling a piece of property and you're wondering about POA, the best thing that you can do is get it to us ahead of time and let us review it. Because that we've had situations where people showed up at a closing and say, hey, I've got a POA that I'm going to use to sign. And we're like, well, we need to review this. We need to take a
Right.
look at it. It's not one of those things like, you can just show up with it and use it. The power of attorney that to use for real estate, it needs to be very specific to the transaction or the ability to be able to use it for your intended purpose, which is to sell real estate.
Right.
So like I say, the best thing for you to do is to get it to us to review so we can see if the one that you have in place, are we able to use it for a real estate transaction. There's certain things that we're going to look at to decide whether we can use it or not. The first thing we typically look at is we're going to look at it and see how old it is. If it's over a year old, a lot of times we're going to ask, what's the circumstances for this power of attorney? Because there's all kinds of situations why an old power of attorney might not be good for us. So we're going to look at for an old. And the next thing we're going to do is why was this power of attorney originally prepared? Was it
Right.
prepared for this transaction, or was it prepared
I
for
imagine
a
that would
different?
be like,
Right.
yeah, okay. I would think too,
Yes.
if it's not very specific, it almost makes sense to have you guys prepare it just for that limited transaction and like that's it.
Yeah,
Right?
for sure. Yeah, for sure. Our number one thing is if possible to have our attorneys prepare a transaction specific power of attorney that again is used just for this transaction. But if for say somebody does have a power of attorney for whatever reason that they want us to review, like I said, we're going to look at things like how old it is, and we're also going to look to see does it have verbiage in there that says you're able to sign deeds or transfer property, because we're
That
looking for that
difference a lot.
specific
Mm-hmm.
right
Okay.
trans information that says because if it's just a broad power of attorney, we need to have it to sit there and say, ability to be able to transfer property, sign deeds on their behalf. Those are the specific things that we're looking for. Now, when I say that it could be over a year old, what's the situation? I know there's sometimes, like you said, a certain situation where, like, for an example, grandma's going to a nursing home and she still has all her faculties about her, but we just want to get a POA in place that says that, we have the right to be able to sign for her for whatever, things that need to come up, selling properties and whatnot. But one thing that we're going to look for in that power of attorney is what we're looking for is called a durability clause.
Okay,
and the durability clause, it's just quite simply just says that the powers that survive if the person becomes incompetent. So if the grantor becomes incompetent, the powers of the power of attorney still survive past that. If there's no durability clause in there, if the person that signed the power of attorney becomes incompetent, the power of attorney is no good. So we need that durability clause in there that says, the powers survive in any incompetency of the grantor of the power of attorney. So that's a main key thing that we're looking for, if anybody's thinking about doing this with a family member. And I think that kind of leads into kind of what's kind of important is there's 3 ways that can make a power of attorney, invalid or terminated. So I guess termination. One is the power of attorney can be revoked at any time by the grantor. So again, that's why we're concerned about how old it is, because if it's a really old power of attorney, it could be revoked anytime.
How would you know that it was revoked?
So the only time that we're going to really be able to see a power of attorney is if it's recorded of record. And if it's recorded of record, then you can record or.
Are they normally recorded?
Well, we will record them with our transaction, and we'll talk about that a little bit later. But you're kind of going off of good faith, and sometimes what we'll do is we'll even have to do what's called an alive and well affidavit that kind of just mentions again that the grantor is alive and well, and that this is still good to go. So some circumstances we may require that. So like I said, it could be revoked at any time. Like we mentioned before, if the grantor becomes incompetent, then again the POA is terminated. So again, that's why we're looking for that durability clause, because if the durability clause is in there and someone becomes incompetent, well, that's already been addressed.
Fine.
So that's another reason. And then finally, the one that cannot be get around under no circumstance is the death of the grantor. So if you have a power of attorney and so-and-so's on the deathbed, if they die before the closing, you cannot use that power of attorney. As soon as a person has passed away, it's no longer valid. And
what happens?
You can't.
Into probate?
Well, yeah, at that point, then a lot of times you're going to have to go through the court and set up a guardianship through the court, and the court, allows you to. Yeah, well, a guardianship will be in case somebody becomes incompetent, but otherwise, yes, if you're going through probate, then at that point that somebody dies. But like I said, if there's a circumstance where somebody doesn't have the durability clause and then they become incompetent, then you're going to set up again a guardianship.
How would you know as a title company that they're dead?
That they're dead? I mean, we're not really going to be able to confirm that somebody's dead. Now, if we have any suspicion at all, we're going to have them sign that alive and well affidavit.
Okay.
So if they sign that alive and well affidavit, then there's fraud. Even if there's not, then there's fraud on behalf. Now, if somebody signs and they are dead, then technically that deed that they're using, their warranty deed is no good. So they're committing fraud in that sense. So, as a title company, we're going to do everything we can to kind of, right. We're going to do everything we can to kind of cross our T's and dot our I's. But, if people aren't honest with us, there's only, so much that we can do.
And you know what? I think this goes back to our conversation about blockchain.
Yeah. No, it does. Really. No, I mean, right. And you think that maybe with blockchain, if somebody passed away, you file that death certificate, that block is now, right, that history set up. So, Yeah, so like I said, death of a grantor is the number one thing that you can't get around. If somebody does die, then their estate goes through probate.
That's
You know,
crazy.
obviously
That's
that's
the
why you always
thing,
want to have your
right?
trust and your will in place and your estate plan in place. And we
Mhm.
have a great attorney that does estate planning that can help people get you know, get that all set up. If anybody's ever interested, they can reach out to me directly. I can get them in contact with someone. But that's again one of the things why you want to have all your ducks in a row because you never
Exactly,
know
and
what's
kind
going
of
to
like
happen.
upfront
So,
what's happening. What about, two
yeah.
questions. So if your deed is in like a company name, can you, the company, I know they have to have the documents that says that the person's allowed to sign, but can you do a POA for a company?
For the, I'm sorry, I didn't quite hear your question. So,
Like if the house is deeded in a company name, can there be like a POA for the company? Or is it
no,
just like only the
yeah,
sign?
typically the company's going to have like a corporate resolution that allows for people to be able to sign. And if and it says these people are able to sign on behalf of the company, if whenever there is a change to that, they'll file a resolution to their
So
document
like,
that
let's
says,
say I own my company and I'm the only owner and I'm the only signer on it, and like I can't do it because of whatever. Could I get somebody else as a POA to sign
you
for
know,
me?
I think again, I'm not an attorney and I don't play one on TV, but I believe you would have to again amend your corporate documents to be able to name somebody to allow them to be able to. Because I don't think you can be a power of attorney of a
Company.
organization. Yeah, you would need to do a change to your resolution, but I'm not positive. I'll have to
We'll have
follow
to,
up on
yeah.
that one.
I don't
Yeah.
think it's up too much. The other question I had is, can anybody be a POA? Or do they have to be like related parties?
No, anybody can be a POA. It doesn't have to be a family
Yeah, because
member or
I feel
somebody
like
related
I've
to the
been a
transaction.
POA for clients before, like many, many years ago. Like they
Hmm.
weren't able to attend the closing or whatever, and so I signed for them.
Yeah, so it's just whoever you want to name as the person attorney in fact. I mean, I think,
Okay.
it can
Well,
kind of
yeah,
be
I
kind of
remember signing that. It was like my whole
mhm,
name for their whole
right.
name, attorney in fact or whatever. It was like, oh my
Right.
God.
And that's what we're going to do every time that, there is a POA involved is we're going to have them sign their documents as POA.
Right.
They're not just going to sign as that person. We need to make it
Right.
known that POA is a
Right.
person.
It's like,
And then the main thing, go ahead.
I was gonna say I remember this one time, it was like it was an estate or whatever, and there were like 5 kids, but only one could come. And so that
Hmm.
one was the POA for all of them. And so
Okay.
he had to sign like all of their names by his
Yep.
power of attorney, or like it was a big long sentence. And I swear we were
Right.
there for, I mean, he got tired. Like he had to take a break,
Yeah.
signing every
No,
document.
I could imagine that. That would be super tedious to have to do that. Well, and that brings us to, the other thing that we'll need to do is what the reason why we're having them sign POA. But what we're also going to do as a title company is we're going to record that power of attorney in your chain of title. So then anybody that does a search of that property sees that the deed was signed POA, but then they'll also see the power of attorney that,
Why is
states.
that important? That
So
they
we be, and that again, that's just going to stop fraud because
okay.
then anybody could sign as a POA, and we don't know if if they really did have a power of attorney to be able to sign on their behalf. So the thing that and we sometimes run into is we need to record the original power of attorney. And that's why a lot of times it gets into the problem with people having one power of attorney for all their transactions. They don't want to give it up to us because they're like, well, this is my document. But the thing is we need to have that POA, the original signed POA to record. Now we'll give it back to you after it's recorded, but we need to have the original because we're only allowed to be able to record original documents. We cannot
Well,
record
all the more
copies of
reason to
documents.
just have one drafted by you guys for that
Right.
specific property. So then when
Exactly.
you're recording it, it doesn't have all the other
Hmm.
personal, like all the other stuff in it. It's just
Right.
a specific thing. It seems a
Well,
lot cleaner.
Yeah, it's a lot cleaner to have us prepare it. We can make it transaction specific. We can say, you have the right to be able to sign and, sign deeds, transfer properties for this. And a lot of times, we're just going to put in for the sale of, our address at 10723 Montgomery Road. And we're going to be very specific to the transaction. That's the cleanest way to do it. It costs a little bit of money because our attorney has to prepare it, but at the same time, then that you've got. Yeah, I know we gotta pay the bills somehow. So, but that's a whole nother story. So, but like I said, we need to have people hand over the actual original POA. So sometimes, again, that's why it makes sense just to have us do it, because then that POA can't be used for anything else too. If you got a big old POA floating around saying you can sign for anything, maybe that's not the best thing to have out there. Whereas if it's specific to your transaction and you're just selling that property once, it's not really going to matter.
Yeah.
So
I think my biggest takeaway here from this conversation is if you're going to sell a property and there's more than one of you, like there's more than one person on the deed and one of those people are not able to attend, let's reach out as soon as possible to the title company to see if they allow for the e-notary and see if the lender would allow for that, or if we need to do a POA.
Right. And let us, if you have a POA, let us review it, make sure that it's good to go, or not, or have us, have one of our attorneys prepare a POA that you can use, that's transaction specific to be able to do what you need to do. I think that, the main thing to get out of this is when you're doing a POA with a piece of real estate, it's not you can't put a square peg into a round hole. You have to have it, matched up for your transaction. And there are circumstances where we can use your POA, but the best thing for us to do is obviously to be able to review it ahead of time, not at the closing, right? And then if not, have us work with one of our attorneys to have it prepared. So.
And they're not that expensive. I mean, we've had clients do it. I mean, it's not. It's not a lot.
And if it's if it's their only way to get the deal done, then sometimes you kind of got to do what you got to do. So.
Well, cool. I appreciate you coming on and explaining that. Thank you.
Yeah. Thanks for having me. Right.